Go ahead and finish filling out the gray forms if you're there. You can just listen. I'd like to call the meeting to order. Thank you all for coming. Tonight we'll be holding a public hearing of the Eugene Planning Commission on appeal of a Willamette Greenway permit, needed housing site review and adjustment review for Lombard Apartments. It's city file WG 183 SR 183 ARA 188, and once again it's known as Lombard Apartments. The applications were approved with conditions by the Eugene hearings official. My name is Kristen Taylor, and I'm the chair of the Eugene Planning Commission. And to start, I'd like the planning commissioners to introduce themselves.
My name's Lisa Fragola.
I'm Tiffany Edwards, Vice Chair.
I'm Chris Ramey.
I'm Stephen Baker.
And now I'd like for staff to introduce themselves.
Good evening. My name is Rodney Bonner. I'm assistant planner and lead staff assigned to the application.
I'm Gabe Flock, senior planner.
My name is Lauren Summers, and I'm an assistant city attorney.
Thank you. So for those of you that have attended a hearing, for this next piece, I'm going to read from the paper just to make sure that I cover everything. So, I'll try to raise my eyes to keep you engaged, but it's important information. I'd like to take a moment to explain who the Planning Commission is and our role. We are unpaid volunteers appointed by the Eugene City Council to 4-year terms on the commission. We all live and work in Eugene. We directly advise our city council on matters related to land use, and we are also tasked with making certain land use decisions on behalf of the city of Eugene. That's why we're here tonight. We're responsible for upholding the laws of our city and our state, the policies of our city council, and of course, at the same time, we're also responsible to everyone who lives and works in Eugene. We're at-large members, which means we have to consider the needs of the community as a whole, as well as the needs of all groups and neighborhoods. We're also human beings, which means each one of us has personal views to make us who we are. But as planning commissioners, we're committed to balancing all of our needs as a community and to making the best decisions we possibly can based on our policies and our laws for us and for future generations. We strive to sort through all the evidence and facts presented and carefully review the pertinent land use code criteria in order to make thoroughly informed decisions as a governing body. This can be pretty tough to do, and we know not everyone will agree with every decision we make, but we do try to make these hard decisions through careful deliberation and to the best of our abilities. The Planning Commissioner's role in this appeal process is to affirm, reverse, or modify the hearing's official decision, conditional approval of these applications. We will deliberate and take action on this item starting tomorrow at 6 p.m. in the Sloat Room. And staff, do you want to explain, because there could be a follow-up deliberation if needed. Is there any additional information you want to provide?
I'll just add that at this point, the hope is to get through as much of the appeal issues as we can through deliberations tomorrow night. We have another meeting scheduled for September 11th. I believe that's next Tuesday at 6 p.m. as well, with the goal of finishing your decision-making process before the end of the statutory time limit, which I believe runs out September 15th. Perfect.
Thank you. The decision of the Planning Commission on this appeal is a quasi-judicial decision. This means we are legally required to have a certain order of speakers, and there are specific rules or criteria on which we must base our decision. First, we'll begin with a brief presentation from staff, and then open the public hearing. If anyone in the audience would like to speak, please fill out a green form in the back, and you can leave it with Alyssa, a staff member, and she'll bring it up to us. And the speakers will be called in the following order: the applicant and those in support of the application, those with a neutral position, and the appellants and others opposed to the application. Staff's response to testimony, and the applicant's rebuttal to the testimony. During this process, the Planning Commission may ask questions of anyone who provides public testimony. The Planning Commission's decision will be the final city decision on this matter. Since we have until September 15th to reach a decision on this application, we will only listen to testimony tonight. Deliberations and final action will take place at the future public meetings that we just discussed. Any additional appeals filed regarding our final decision will be brought to the State Land Use Board of Appeals. The purpose of tonight's hearing is to receive relevant testimony on the appeal before us. I want to remind everyone that your testimony must be directed towards the issues identified in the appeal statements and the applicable approval criteria from the Eugene Code. No new evidence can be accepted by the Planning Commission, and we can only accept testimony related to evidence that is already in the record. And I'm going to ask staff and Planning Commissioner members to speak up if there's a concern tonight. What this means is that you should be testifying about the materials and information already presented to the hearings official and whether or not you think the hearings official made a mistake based on the approval criteria and the evidence available at that time. I want to remind everyone that the failure to raise an issue with sufficient specificity to allow the Planning Commission and parties to respond will preclude future appeals on that issue. In other words, now is your opportunity to raise issues as clearly as you can so that the city and other parties can address them, as long as it's no new evidence, obviously. Before we begin, the Eugene Code also requires that planning commissioners disclose any conflicts of interest, ex parte contacts, biases, or abstentions. In a quasi-judicial proceeding like this one, the parties are entitled to an impartial or neutral decision maker to ensure this fair consideration. The Eugene Code and the Planning Commissioner's rules, or the Planning Commission's rules, attempt to limit ex parte contacts or communications between a party and the decision maker outside the public hearing process. Each planning commissioner must disclose and describe the substance of any communication they have had about this application outside the public process. The planning commissioners must also disclose any potential conflicts of interest. That is, whether the decision they are about to make could or would result in a personal financial gain to themselves, their business, or a member of their household. Finally, a planning commissioner cannot participate if he or she is biased. That is, for whatever reason, he or she is incapable of rendering an objective decision on this appeal. So I am aware of a challenge of impartiality that I'm going to have Lauren talk about.
Sure. Thank you, Madam Chair. So this afternoon, we received a challenge to the impartiality of Commissioner Randall, who's not here tonight. The challenge was made by Paul Conti, and I have it here. I'll place it into the record for the Planning Commission because that's required by the Eugene Code. But I don't believe that the commission actually needs to address the challenge because Commissioner Randall is not present tonight and will not be present for any of the deliberations around this appeal. He has prior commitments, he's on vacation, and he won't be participating in the decision. So we will place this into the record, but because Commissioner Randall won't be participating, there's no need for the Planning Commission to make a decision about his impartiality.
Perfect. Thank you. Do any other commissioners have any conflicts of interest or ex parte contacts to disclose?
Yes, Commissioner Taylor, I do have something to speak about. So I attended the River Road Santa Clara Neighborhood Plan Working Group on Wednesday, August 22nd. And there was an individual at that meeting who started to speak about the Lombard apartment development, and when I realized what he was speaking about, I got up and left the room because I knew that this hearing was coming up and had staff let me know when he was finished speaking. That situation does not impact my ability to make an impartial decision.
You said it already, Commissioner Fraggle, but I'll just ask you again. You feel that you can make an fair and unbiased decision based on the evidence and argument in the record before you?
Yes, I feel that I can do that. Thank you.
Great. Does anyone in the audience or a member of the commission wish to challenge the impartiality of any of the planning commissioners? And I want to add that any person during your testimony, you have the right to rebut the substance of the ex parte communications just disclosed. So we're going to begin with a brief presentation from staff. Rodney Bonner from Planning Division will provide information about the application at hand.
Thank you, Madam Chair. I don't believe anyone's new to the application, so my presentation will be relatively brief to give plenty of time to hear your public testimony, which is the reason of our meeting tonight. Again, this is the Lombard Apartments. This is 3 applications. Each has their own approval criteria, which are listed in the code under the Greenway Permit, Site Review, and Adjustment Review. How we got here today, the application was resubmitted. It was initially submitted and then withdrawn. The revised application for the project was submitted and deemed complete on May 11th. A public hearing was held in late June before the Eugene hearings official. The hearings official issued a timely decision approving with conditions the 3 applications. An appeal was filed by the appellants. The appeal was timely, and we are here today for the public hearing before the Planning Commission. As mentioned earlier in the introduction, there will be deliberations tomorrow night at 6 p.m., and that is in the Sloat Room in the Atrium Building. And if need be, there will be another deliberation on September 11th, Tuesday, also in the Sloat Room at 6 p.m. And our decision is due to statutory law. The 120-day cutoff for the decision at the local level is due by September 15th. The subject site is highlighted in red. This aerial with the highlighted park area shows the undeveloped property, approximately just over 3.5 acres, located at the northern terminus of Lombard Street, which comes into the middle, approximately middle of the site to the south, with frontage to River Road on the west, and to the east sits a City of Eugene Parks and Open Space bike path, and City of Eugene Parks property, and then the Willamette River. To the southeast is Maury Jacobs Park. The entire site is zoned R2, medium density residential. There are also 2 overlays that they're not shown on the map that you see, but the entire site has an ND nodal development overlay, and the southern square has a site review overlay. The entire site is also located within the bounds of the Eugene Willamette Greenway. The applicant is requesting approval of, as I mentioned, the Willamette Greenway permit, site review, and adjustment review. The applications are to construct up to 94 market rate residential apartment units. In this case, the applicant has requested all of the applications be reviewed concurrently under the Type 3 application procedures. This is another diagram of the site. As you can see, a new public right-of-way is proposed down the middle, which would extend Lombard Street to the property's northern terminus. The applicant has also applied for an adjustment to allow open primary access on River Road. With that, I'm sure everyone's familiar, and that concludes the staff presentation.
Okay. So before we open the public hearing, I want to go over a few procedural items for tonight's hearing. As previously mentioned, we have until September 15th to reach a decision on this appeal. And if you have any questions after the hearing in terms of deliberations, just ask staff. I understand that the applicant and appellants have agreed that each will have 30 minutes to speak, and that could be a group, one person, a group of people. The applicant has reserved the final rebuttal period. Individuals will be limited to 3 minutes for testimony to allow for everyone to have a chance to speak this evening. And I think I'll have, Christy, do you mind, Commissioner Ramey, do you mind watching the clock on that?
As long as I know what that means exactly.
Okay, okay,
Is
perfect.
there a literal clock I have to watch, or
No, you can watch your own.
put a time?
Okay.
Got it.
And now I'd like to open the public hearing of the Eugene Planning Commission. If anyone would like to speak, once again, go ahead and fill out the green form. We have green forms already up here, so if you've already filled them out, they are with us now. Please, when you come up to the podium, state your name and your address before beginning your testimony. And like I said, we're going to start with the applicant and those in support of the application. And through the process, planning commissioners, if you have questions, please ask the questions after each speaker. Okay.
Okay, I'll go ahead and call up our first, the first folks to testify here is Hans Christensen and Mike Reeder with the applicant.
Hi, I'm Hans Christensen with Evergreen Housing Development. I'm the Planning and Entitlement Director, and our address is 601 Union Street, Suite 16, Seattle, Washington, 98101. And I have Andrew Brand, our Executive Director of Development, with us.
Hello, I'm Andrew Brand with Evergreen Housing Development Group, also at the same address, 601 Union Street, Suite 616, Seattle, Washington, 98101. I just wanted to open up to give a little bit of context and background to our initial coming to this site and looking at it as a multifamily development site in relation to some of the things that the appellants have raised regarding sort of the ideas of what this site should be used for. So in short, you know, when we first became aware of this site, it was zoned R2, had been zoned R2 for quite a long time, for a number of years, which allows multifamily housing outright. But more than just the R2 designation, what actually got us interested in the site for a multifamily use was its eminent access to multiple modes of transportation. You can walk to the Valley River Center in 7 minutes. You can be there on bike in 2 minutes. River Road itself is slated to become a transit corridor and will be the location of the next rapid bus transit line in the city. The other thing is, you know, talking about bikeability, the Ruth Bascom Bike Trail being right in that next to us really provides just wonderful bikeability to the majority of the densest parts of the city, majority of employers in the city, all within anywhere, as stated before, from a 2-minute bike ride to go to the Valley River Center to perhaps a 20-minute bike ride to reach University of Oregon, Outson Stadium, and downtown. So really it's just exactly the case, really exactly the place where we want to encourage density. As a developer, where we think that from a growth management perspective, density should also be encouraged. So with that, I will end my testimony. Thank you.
And I'm just here to add a little bit of, I guess, clarification. These are all things that are in the record already, but just clarifying a little bit here that our setback from the river is measured from the top of bank, which is near the bike trail, but in fact, the river is an additional 150 feet away from that top of bank. So in addition to that 100-foot buffer that's imposed upon our site from the top of bank, there's an additional 150 feet. So really, there's going to be open space of over 250 feet between the river and any development on our site. There's been some appellants have brought up building heights and compatibility, just pointing out that our leasing office, and this is all found in our elevations, leasing office maintenance buildings are 1 story, the buildings 3 and 4 are 2 story. Building 2 is a 3-story building, but is set into the site over close to 60 feet. And then building 1 is a combination of 1 and 2 stories, with 2 stories being at 3 and 2, with 2 stories being at either end of the building, and that's can be seen in the elevations of building 1. So these provide some transition and compatibility with adjacent uses. With that, I'll hand it over to our legal counsel, Mike Reeder, to more formally address the appeals.
Mike, when you get a chance, can you just fill out a green form?
I already
Did you?
did.
He's got it on there. Oh, perfect. Sorry, I didn't know he had it. Okay.
Chair Taylor, Planning Commissioners, thank you for your volunteer service. Thanks for being here tonight. My name is Mike Reeder. I'm the attorney for the applicant for this application that is before you on appeal from the hearings official. My address is 375 West 4th Avenue, Suite 205, Eugene, Oregon. Tonight, I want to go through most of the appeal issues that have been raised. Staff did a good job in their agenda item summary in summarizing the hearings official's decision, summarizing the appellant's arguments, as well as staff's position. So our position tonight is that the hearings official got it right, that the Planning Commission should affirm in totality, there is no modification needed. So the hearings official approved all 3 applications with conditions of approval and found that the needed housing statute that is referenced throughout the hearings official decision and in our materials does apply. So he did 2 things. He found that the application met the substantive criteria of the Willamette Greenway, in addition to the criteria for site review and the adjustment review. But then he also went the extra step, as we asked him to determine that the what we call the needed housing statute, or to be more precise, the clear and objective requirements of the needed housing statute, ORS 197. 303 at SEC, that those apply to the Greenway, and that the city is not allowed to impose the Willamette Greenway substantive criteria to this application. So he did 2 things, he did them correctly, and we ask that you affirm the hearings official's decision. So I will go through that in greater detail following the lead of the staff's AIS. So I've provided for you tonight in hard copy a hearing letter wherein I go through these appeal issues. So if you like, you are welcome to refer to that. And I'll be starting on page 2 of my written material, which the first issue is that the hearings official, this is the assignment of error, or the issue raised by the appellants. And it's not the appellant's first issue, but it's the first issue tackled by staff. And that's appeal issue number 1. And it reads, the hearings official erred in finding that the Willamette River Greenway approval criteria do not apply to the subject application. So the appellants assign error to that, and the city attorney's office has provided a supplemental memo that supplements the original memo that was before the hearings official, wherein the city attorney's office took an opposite position. I'm not going to give a lot of time to that particular issue because, frankly, we believe that we meet the criteria for the Willamette Greenway. So in our estimation, the Planning Commission can affirm the hearings official's decision based on the substantive criteria as well as this issue. So I'm going to go through it rather briefly. If you have any questions about this particular appeal issue, please let me know, and I'd be happy to clarify those. But quickly, I will address for you the fact that the hearings official did not opine on this matter. The hearings official actually went through a pretty rigorous analysis of why he felt that, for lack of a better word, I'll call it the needed housing statute that requires that the city impose only clear and objective standards on housing. Why that, and for lack of a better word, trumps the Willamette Greenway statewide planning goal 15 and the statute that implements that, which is ORS 390-314. So it's the city's position as well as the appellant's position that the Willamette Greenway provisions of the goal and of the statute require the city to impose these substantive, subjective criteria, okay? Now, we have argued, and the hearings official agreed, that the needed housing statute, as amended in Senate Bill 1051, 2017, requires that the city impose only clear and objective standards for all housing in the urban growth boundary. And that includes housing that is allowed in the Willamette Greenway. So the appellants in this appeal issue, they talk about, and I'll just quote, the appellants say this hole in the Greenway provisions proposed by the hearings official is wide enough to place a 94-unit multifamily apartment complex in it, which does not give effect to Goal 15 or ORS 390-314. So remember, Goal 15 is the Willamette Greenway goal, statewide planning goal. The problem with that analysis is that the Greenway, the Willamette Greenway Goal 15, as well as ORS 390-314, is not imposed, it was not adopted to prohibit development within the Greenway. The city council has already determined that even implementing Goal 15, that housing, in this particular case, multifamily housing in the R2 zone, is an appropriate use within the Greenway. So I want to make that clear, because if you only read the appellant's arguments, you get the sense that no development should occur. Now, if you back that argument off a little bit and say, well, some development can occur, but just not as much as what the applicant is suggesting, 94 units. The problem with that argument is that it is unclear to the applicant, and it's unfair to the applicant to guess what the right level of development is. So the rules of the game are embedded in the R2 zone, which allows for a density of 20 units per acre. In addition, this property, as discussed by Andrew Brown, this property is in the nodal development overlay, which actually encourages more density. And for reasons articulated by my client, this is a great location for density. You're along a major transportation corridor. You are along the Ruth Bascom Bike Trail. You're next to some major parks. You're next to major commercial centers. This is where density ought to go. And it's been designated medium density residential and zoned R2 for quite some time. Moving on to appeal issue number 2, that appeal issue is the hearings official misconstrued applicable law and made findings not based on substantial evidence with regard to Eugene Code 9.8815 sub 1. So this is the first criterion of approval for the Willamette Greenway. Again, you can analyze this two ways. One is, the first thing to do is to analyze to see if the application meets the substantive criteria as articulated in this code provision, provision 1, and then 2, determine, as the hearings official did, that this is actually subjective criteria that the needed housing statute doesn't allow you to consider. So you can do both things. You can do just as the hearings official did. In this particular case, the application meets this criterion for approval. The hearings official got it right. And this provision says, to the greatest possible degree, the intensification, change of use, or development, and in this case we're talking about development, will provide the maximum possible landscaped area, open space, or vegetation between the activity and the river. So the analysis is what is going on between the river and the activity, or in this case, the development, or the closest development. And as testified by my client, the closest building to the river is actually about, the closest point of the closest building to the river is actually 250 feet away from the river. Okay, so it's pretty far away, and there are intervening parcels between the subject property and the river. So the appellants don't provide you with what they believe would be an appropriate location for the development. They merely say that the applicant didn't provide enough evidence to support a finding that the development is to the greatest degree possible, or greatest possible degree, providing the maximum possible landscaped area and open space. Now you can kind of see, as an editorial note, you can kind of see why the state legislature imposed requirements that we have clear and objective housing standards. It's precisely for reasons such as this. But in any case, we believe that 250 feet is a generous amount of distance between the river and the activity. And if you were to go along the river, you would not see the development, or you'd see very little of it, because as you can see overlaid on that map, there's quite a bit of mature vegetation between the river and the site. So lastly, on this appeal issue, as delineated by the applicant's environmental consultant, there is not just a 70-foot setback as the appellants maintain, but there's actually 250 feet from the ordinary high water mark, not even the low water mark. So the low water mark, there's actually vegetation between the low water mark and the high water mark. So just going to the ordinary high water mark, there's 250 feet separation. The appellants talk about that the applicant needs to go through some type of balancing of the factors, but I don't see that in the criteria for approval. Appeal issue number 3, the hearings official misconstrued applicable law and made findings not based on substantial evidence with regard to EC 9.8815 sub 2. So this is the second Willamette Greenway criterion for approval, the subjective substantive criteria for approval, which states that to the greatest possible degree, necessary and adequate public access will be provided along the Willamette River by appropriate legal means. Now, we agree with staff on this and the hearings official that this provision requires the greatest possible degree, necessary and adequate public access along the Willamette River. So this property does not abut the Willamette River, so it's not possible to provide access along the Willamette River, and so therefore it's not an applicable provision. By its terms, it is not applicable. Secondly, and perhaps more importantly, even if you were to interpret this substantive criterion to require that my client provide an access easement from the subject property to the river, such a requirement would not be appropriate. It would not be a legal means to do so. And the reason is because the U.S. Supreme Court has provided in the Nolan case and the Dolan case, that there be an essential nexus between the exaction that's required. In this particular case, it would be an easement through my client's property to the river, and the some type of mitigation. It'd be difficult to say that because this property would be developed, that somehow there's a harm being done that requires mitigation, requiring traffic through my client's property. There's simply no nexus. So because of that, there's not an appropriate legal means to require my client to do anything as suggested by the appellants. And this appeal issue actually raises a point that I want to emphasize, which, again, this is a great location for housing in Eugene, multifamily housing. This property is located at the intersection of the West Bank Path as well as the South Bank Path of the Ruth Bascom Riverbank Path, and there's the Maury Jacobs Park to the south, as well as the Razor Park to the north. This is a wonderful location for housing. It would be, it would provide that type of amenity for another 94 families and individuals here in the community. Issue number 4. The hearing's official misconstrued applicable law and made findings not based on substantial evidence with regard to Eugene Code 9.8815 sub 3. So this is the third Willamette Greenway substantive criterion that the appellants take issue with. And this provision reads, the intensification, change of use, or development will conform with applicable Willamette Greenway policies as set forth in the Metro Plan. So if you go through the Metro Plan itself, there are a number of Willamette Greenway policies, none of which are applicable to this application, except for perhaps arguably the one that's cited by the hearings official, by the appellants, and in my written material on page 5. So that is, that policy is section 3D, policy D5. So policy D5 states, new development that locates along the river corridors and waterways shall be limited to uses that are compatible with the natural, scenic, and environmental qualities of those water features. So what does this criterion require, if it requires anything? Well, it requires that the uses be compatible with the natural, scenic, environmental qualities of the water features. The problem with the appellant's argument is that they seem to be concerned about the height of proposed building number 1, which is 35 feet, which is the maximum allowed in the R2 zone. The problem with that argument is that that is not a type of use, okay? That is a development standard. The type of use is multifamily residential. And we know that that is allowed. We know that that's appropriate because the city council has already determined that that's an appropriate use. The development standards are in the base zone of the R2 zone, and that is, the maximum height is 35 feet. And it's important to note that the applicant is not seeking an adjustment or any type of variance from that standard of 35 feet. Appeal issue number 5, the hearing's official misconstrued applicable law and made inadequate findings not based on substantial evidence with regard to the density calculations for the subject development. So this is the argument that was made that the proposed internal driveways and parking drives are somehow considered streets, and therefore they should be backed out of the net density calculation, and that the leasing office, the maintenance building, and the open space also should not be counted toward net density. This is a preposterous argument, and the hearings official goes through a very detailed analysis of why. And the reason is because there is meaning attached to these features. Driveways are defined by the Eugene Code, parking drives are defined, and streets are defined. So to suggest that the internal parking drives and the driveways are somehow streets is a real stretch. It's a non-starter, and the hearings official wasn't having any of it. So the hearings official got it right. Additionally, the idea that the leasing office and the open space and the maintenance building somehow are not part of the residential development, again, is preposterous, merely because there are going to be people who are not current residents that may use the leasing office to go in to lease the property, and merely because there are employees that will work doing maintenance, that does not somehow kick those uses into the public realm, therefore needing to be, as argued by the appellants, needing to be netted out of the net density calculation. It's absurd. If you take it to its logical extreme, it would mean that any residential unit that invites anybody who's not a resident over would somehow be public, and therefore you wouldn't be able to count that space in the net density calculation. If it was some other type of mixed use, that had some type of commercial use or something like that, or public use, perhaps there would be an argument. But simply because the accessory residential uses are there on site, that's not a reason to debit out from the net density calculation. So again, the hearings official got it right. Issue number 6, there's really not much to say in that regard. If you have any questions, I'd be happy to answer those. Issue number 7, the hearings official misconstrued applicable law and made inadequate findings not based on substantial evidence with regard to 9.6815 sub 2 sub F. And this is the ask of the appellants that the applicant provide temporary bollards or some type of barrier that would restrict access along the extension of Lombard Street. And the appellants argue that, hey, Lombard, the existing Lombard Street, the paved surface is inadequate. The problem with that argument is that the provisions of the Eugene Code that talk about connectivity and adequacy of the surface, well, there's a couple of things. One, the Eugene Code really wants connectivity, so that's the first thing. But the second thing, and the more important thing, is that the driving surface adequacy is a determination made by the Public Works Director, not by the hearings official, not by the Planning Commission, not by the appellants, and not by the applicant. And in this particular case, the Public Works Director determined that the driving surface on Lombard was adequate. Is it perfect? Probably not. There's evidence in the record that shows that it's not, but you know what? There's not a whole lot of perfect streets in Eugene, unfortunately. But the standard does not require that the Planning Commission determine whether or not the driving surface is adequate. Issue number 8, the hearings official misconstrued applicable law and made inadequate findings based on not based on substantial evidence with regard to a number of provisions in the code. Again, the staff AIS does a good job of discussing this, and there's really, it's not an argument that's sufficiently developed to respond to. Same thing with issue 9, except that I would, although this argument is not well developed, I would say that the applicant has provided detailed elevations of the proposed buildings which show the proposed articulation, building entrances, private patios, and decks, and that's in the record. So you can actually see the building elevations and see how the application meets the criteria for regarding the building mass and facade issues. Issue number 10, the hearings official misconstrued applicable law and made inadequate findings not based on substantial evidence with regard to Eugene Code 9.6735 sub 2. Here the appellants are arguing that the hearings official's findings are conclusory and therefore not based on substantial evidence. However, as staff noted on page 14 of the AIS, the record includes substantial evidence to support the hearings official's findings of compliance with the issue here is public access standards of the Eugene Code, including justifying the adjustment to Eugene Code 9.6735 sub 2, which is the ask by the applicant that the primary access be taken from River Road. Now this argument by the appellants is curious because it seems like much, if not most of the opposition has to do with the concern about Lombard and access to Lombard. Well, in reality, the application really wants to take access, ingress and egress access off of River Road. That's the primary location that we're proposing, but because of the code, we're required to seek an, even though it seems to be common sense in this particular case, we still have to seek an adjustment. So to attack the application and the hearings official's decision based on the fact that we're asking for an adjustment that has been thoroughly justified by not only Public Works engineering staff, but also by Ms. Sandow, the applicant's traffic engineer, is somewhat curious. So there is evidence in the record to support the finding that the hearings official made. And again, that's the referral comments of June 13th, 2018 from the city's Public Works engineering staff, as well as the traffic engineer, Kelly Sandow, of Sandow Engineering. Both of those pieces of evidence that are in the record conclude that the proposed access to River Road will provide safe ingress and egress. And then appeal issue number 11, I will close with this, is not sufficiently developed for this on the record appeal hearing. You can't simply try and incorporate by reference arguments made by others. You have to be, the Eugene Code EC 9.7655 sub 3 requires that the appeal issues be specific, and here they're not specific. It's a scattershot approach. So appeal issue number 11 should be rejected for that reason. I'll reserve the remainder of my time for rebuttal, and I'm available for any questions that the Planning Commission may have for us.
Do any planning commissioners have any questions for the applicant? Commissioner Baker.
Yeah, I just have a question. It's more to the developers, but I notice on the drawing, the attachment B that we have, it shows building 1. It may not affect the issues, but it shows it all as 3 stories. It doesn't show it as 2 and 3 stories. Is that just an error in the drawing then, or change?
It may just be on that particular exhibit. It doesn't have the necessary detail to show you that, but
Okay.
the ends are stepped down to 2 stories for approximately, I think, and just going to say approximately because I don't have it in front of me, but I believe about 30 feet on either end before it steps up to 3 stories.
And for clarification, those elevations are found in the record.
Are there any other questions? Okay, so we'll move, thank you very much. We're going to move to the neutral position.
No, I've
Sorry.
I've got one
Of course,
more.
there's potential public testimony. Sorry about that.
That's okay. So I'll go ahead and call up Bill Close, who's speaking in favor of the project.
Sorry.
That's okay.
The 3-minute clock?
Bill Close, you are on the 3-minute
How
clock.
sad. Bill Close, same street address as Mike Reeder, Suite 204. Representing the home builders. Home builders' stake in this, their dog in this, is the needed housing statute. My client's into full implementation of the needed housing statute, which, based on our experience, planning staff in the city is fairly hostile to, based on a number of examples we can talk about. The hearings official got it right. The hearings official had the question of whether the needed housing statute applies to this site briefed by four competent attorneys. Mike Reeder for the applicant, I think Sean Malone for the opponents, Lauren Summers for the city staff, and me. I'm probably fourth because I'm the least competent. So there you have an impartial attorney acting as hearings official that said, based on all that briefing, this site gets the benefit of the needed housing statute. Clear and objective standards only. There aren't any clear and objective standards, no standards to apply. You don't need this permit. That's the position that a home builder is going to defend and take to LUBA, if necessary. Now, I think you're going to agree with the staff attorney and throw the needed housing statute and the hearings official's decision under the bus. They have kind of an advantage. I think they see you as a softer target than the hearings official. I'm starting with that as an assumption. But my caution to you is do not then do what the neighbors are asking you to do, which is also to find that the discretionary standards apply and find that this application does not meet the discretionary standards, because then you'll be into a denial. And that denial is going to be appealed to LUBA. And at LUBA, we're going to say, needed housing statute applies. None of those discretionary standards can be applied, period. And there's no basis for saying no to this. And LUBA is going to reverse the denial and order an approval, and then award attorney's fees, which are mandatory under state law. Just like they did in the Walter versus City of Eugene case a couple years ago, Southeast Hills needed housing statute PUD. I mean, that's the model. So that's the risk for you out there. It's always great to get attorney's fees at LUBA. It doesn't happen very often, like the brass ring. But that's kind of the way this is all going to go if you agree with the neighbors that it doesn't meet discretionary standards, and you agree with the staff attorney that it's not entitled to the protection of the needed housing statute. So that's the big glossy picture. I'm happy to answer questions. I could talk for another 5 minutes quite easily, but my 3 minutes is probably up. Any questions?
You have 25 seconds.
I think I
10.
pretty much have said it.
Perfect.
I'll save it for the next hearing. Thank you.
Thank you. So now we are going to move on to the neutral position. We have one person speaking, and I'm going to go ahead and call up Cameron Ewing.
Hello, I'm Cameron Ewing. I live on 445 Noop Lane, Eugene, Oregon, 97404. I'm here on behalf of the River Road Community Organization, and I'm going to read this statement from our last executive board meeting. We have submitted a prior letter indicating our intention to support the opponents in their appeal and co-signing the appeal application for this project, demonstrating our involvement in this appeal. We also wish to submit a single request, which is to provide adequate vegetative screening on the eastern edge of the property. This is the edge adjacent to the City of Eugene's West Bank Park. The entirety of both north and south edges of the property are shown to have high L3 screen requirements on page 16 of the developer's conceptual landscape plan. But the east edge, the one most impactful to park visitors, shows only retention or replacement of existing trees and grasses. Numerous neighbors testified at the original hearing by the hearings official that this project needs to be more compatible with the surroundings, but generally they didn't provide specific examples of how that compatibility would be provided. To increase this project's compatibility, we request that the developer be required to plant L3 high screen along the east edge of the property in addition to the developer's retention or replacement of existing trees. This request is submitted by unanimous vote of the River Road Community Organization Executive Board on August 13th, 2018. Thank you.
Thank you.
So I have a question for you, Cameron. So I just want to clarify, you submitted it, your testimony is neutral, but it does sound like you're opposed. So I just want to get a clarification in representing the.
Yeah, so we are supportive of anybody in our neighborhood appealing anything as a neutral party. So that's a standard policy of the River Road Community Organization. And although we are trying to, as much as we possibly can, to stay neutral on this subject, we have this one request that vegetation be planted on the eastern edge of the property for compatibility reasons.
Thank you for the clarification. Are there any other questions? Okay, thank you.
Okay. All right, I'm going to move on to the opposition. And the first speaker I have is Julie Hume.
And this is, it should be the appellant.
Oh, I'm sorry.
So you have the 30 minutes.
This is
Right.
appellant, and
And there are how many speakers on behalf of the appellant?
1, 2. Hold on here. It looks like I have 6.
Okay, so there's 6 speakers in the 30 minutes, is that correct?
Up to 6, 5 or 6.
Okay, perfect.
Thank you very
Okay,
much.
yeah.
Good evening, and thank you for the opportunity to address you all this evening. And I promise, unlike some of the prior speakers, I won't threaten you. I do want to mention my name is Julie Hume, and I've resided at 455 and a half River Road for the past 35 years. The Willamette River Greenway, currently consisting of nearly 100 public parks, is a cradle protecting the precious Willamette River. In a visionary and collaborative process dating back to 1967, former Governors Straub and McCall joined with the legislature to protect the river system for scenic and recreational purposes. Land Use Goal 15, further detailed acquisition and protection of the Greenway. Eugene was a notable exception to Oregon cities receiving grants to purchase the riverside parkland. Our community instead so deeply treasures the Greenway that active supportive groups and local government work together to purchase lands to ensure protection in perpetuity. This relationship between community and the Greenway is alive and thriving today. One of the last remaining available parcels of land in the local Greenway is being threatened by the proposed Lombard Apartments by Evergreen Housing Development Group. Long slated for modest, affordable housing project by Homes for Good, formerly Hacksaw, it is poised to be sold to the out-of-state developer for 94 unaffordable homes. The proposed development violates EC 9.5500, the multiple family standards, by not enhancing the character and livability of our neighborhood, not making a positive contribution to our area, not promoting building and site design that contributes positively to a sense of neighborhood, and not ensuring the design provides for a sensitive transition to nearby less intensive development. The entire parcel of land lies within the Willamette River Greenway and deserves the protection of the Willamette Greenway permit approval criteria and standards. I agree with the city attorney and the detailed memorandum that was issued, as well as the planning staff's report, that the hearings official erred in finding the Willamette River Greenway approval criteria do not apply to the Lombard apartment application. Furthermore, the hearings official clearly erred in determining that, quote, the applicant has placed all of the development in the western portion of the property as far away from the river as possible, end quote. In fact, and we can see on the previous map displayed, which I've also attached for your perusal, the majority of the proposed development, 24 units in one 3-story building, 54 units in another 3-story building, totaling 78 out of the 94 units, is located in the most eastern portion of the parcel. This flagrantly violates EC 9.8815, criteria number 1 and criteria 5A. Instead, I urge the Commission to utilize the 7 pillars of Envision Eugene and apply the Willamette permit approval criteria, reverse the hearing official's decision, and deny the Lombard apartment proposal application. This is a crucial decision that will directly impact the Willamette River Greenway legacy in our community for many, many years to come. Thank you.
Next up, I have Rob Handy with the appellate.
Good evening, Commissioners. Rob Handy, 455 and 1/2 River Road. And I know many of you have been at civic duty for a long time, and I just appreciate what goes into that, and a thank you for your service. And we have quite a history here in our area when it comes to the Greenway. I don't know if any of you had a chance to meet Mel Jackson. He taught a lot of people in this area their outdoor skills, and I was one of those folks. And rest in peace, Mel. One time, Mel took then Lane County Commissioner Bob Straub out on the Willamette River, a little bit upstream from here, to see the inappropriate development that was taking place on the river. And Bob Straub, who later ran for governor, he was amazed what was taking place along our river and in our community. And when Bob Straub ran for governor the first time against Tom McCall, he floated the idea that Mel Jackson and he crafted about a Willamette River Greenway. And it was so popular that when Bob Straub went around the state campaigning, he had a canoe on top of his car, and people just loved talking about this idea of the Greenway. I mean, we have the bottle bill, we have public access to beaches, and so many wonderful, iconic things that Oregon has become known for. So in that campaign against Governor McCall, it was such a good idea that Governor McCall took it as his own, and he championed it during his second term as governor. And then Bob Straub did get elected governor, and then he carried on championing the Greenway, and there we are. We have it today because of that kind of vision and legacy that Oregonians are known for. And we have that legacy before us today that you all can support, and I strongly urge you to deny this application. And there's many good reasons for that, and you can do the right thing, and I urge you to do so. Thank you very much.
Thank you. Next up, we have H.M. Sestaida? Sestaida?
I'm Maya Sestaida. I live at 505 River Road, and I agree with the developers that this land should be used for needed housing. The difference is what kind of needed housing. They make market rate apartments, and in the city of Eugene, we have a glut of 8,000 empty market rate apartments at any given time. What we need is 15,000 low-income apartments for the people who can't begin to afford to live in a house built by Evergreen. So this property at one time was designated for low income. It was determined that they couldn't build it there because of a floodplain. Well, the floodplain has been changed by Evergreen easily, and it no longer sits in a floodplain, according to the new records. So there is no reason why this property can't be returned to who really needs it. Low-income people who need places to live. And the report lately is that the Housing Authority has big dreams of building only 300 low-income housings in the next 6 years, while Evergreen has a plan to make more than 400, not on top of this 94, in the Eugene area of more market rate apartments which will remain empty, a glut of unneeded housing. That's not the needed housing that Eugene needs. And Eugene has to be able to have the criteria to say, what is our needed housing under this Oregon mandate that says needed housing? We can't just say all housing is needed. We need to be more critical in how we determine that. And I think that you guys have that ability to say, what is the needed housing that we really need? Thank you.
Thank you. All right. Next for the appellate, we have Lauren Shine.
Hi, I'm Lauren Shine, and I live at 485 River Road. And I want to say that where we live is really beautiful. And there are times when I think it's one of the best places on earth. And if you could just tune out the traffic on River Road, it probably would be. And our friends from Seattle, well, I doubt they'd ever be my friend, but they, you know what traffic is like in Seattle. I think they want to bring that to River Road. It's already bad enough. And 94 units coming out, it doesn't matter whether it comes out of Fur or the driveway on River Road. It's going to overwhelm the traffic that's there now. It's hard enough at certain times of day to get around. I want to say something about this Lombard situation. Mr. Bonner, could we see that colorful map, please? You know that it's called Lombard Lane, and yet on all the exhibits, it's Lombard Street. And I do believe that Eugene makes a differentiation between a lane and a street. And I think that the applicant doesn't want to mention that because they really want to turn it into a heavy-duty street, which will have to affect the houses that are on that street. Now, I asked Mr. Reeder and his friends, well, why, if you want to come build something on the property, why can't you just build what's buildable on that property? Why do you have to destroy Lombard Lane, make it wider, and have 100 or more uses on it per day? If your idea for the property is so great, why not have it where you can just go in and out? Obviously, what you're counting on is too much usage of traffic in that area. Remember, this is not Seattle. I know that you guys like to come here and get rich, but some of us don't care to get rich. We just want to live in peace in this beautiful area. How much time do I have?
Well, your team, the appellant, has about 12 minutes.
Oh, I see. Okay. I'm trying to remember what else I had to say. Oh, yes. I noticed that.
You have 17 minutes. You have a little bit more.
Okay. I'm only going to use a couple minutes. So I noticed that the applicant changed his tune a little bit this time about how wonderful the area is and has all that. It's so perfect for transportation and the bike path and all that. And somehow they were able to get this property, which I do believe they don't own yet. Isn't that right? Mr. Bonner, is that right?
Taking questions right now.
Okay, well, technically, I think pretty sure they don't own it because I think this is it's not going to close until they get their way. But I keep hearing them referring to our property or my client's property. Well, they don't own it yet. And if we get that, and if we get our way, they won't own it at all. You know, Hacksaw, which is now called Homes for Good, used as some of their reasons for not being able to have low-income property was that there wasn't enough transportation there, and there wasn't enough shopping, and everything was too far away. And then suddenly, like with the floodplain suddenly changing, this is such a great property, and we have great transportation there, and this new EMX is coming in, and whoopee. But all of that would destroy our area. And it's very inconsistent, and I think that there are some things that need to be investigated about how Hacksaw made this deal. And I expect that that's going to happen. As you can see, I'm quite emotional about this. These are our homes. There's plenty of places in Eugene to build monstrous developments, like a lot of the modern stuff that is now getting put up. This is not Seattle, this is Eugene. Once it was a garden, and maybe it'll be again. Thank you.
Thank you. All right, thank you. Next up, we have Charles Woodward, the fourth.
Good evening, Commissioners. My name is Charles W. Woodward IV. I live at 44 West 35th Avenue here in Eugene, and I'm the attorney representing the appellants. Although the other issues presented in the appeal statement remain valid, reasons requiring reversal of the hearing official decision, today I'm only going to address a few of the issues. And you'll excuse me if I read, much like, I just want to make sure I get the important things across to you. It's not out of a lack of respect or something, no pointing or presuming what you're going to decide. The first issue that I'd like to address concerns the applicability of course, the Willamette River Greenway approval criteria. The applicant argues, of course, that the Greenway criteria do not apply. However, the memo provided by the city attorney, the staff report, and the appeal statement all clearly lay out the erroneous nature of the applicant's assertion and support the application of the Greenway approval criteria to this development proposal. Allow me to be the fifth attorney to throw my hat in the ring, and I'll gladly go below Mr. Close's stands. The legislative history as described by the city attorney is evidence of the legislature's intent as regards the interaction of the Greenway and Goal 15 with other land use provisions. And rather than regurgitate all the analysis, I'll summarize with a quote from the conclusion of the memo. Various statutes requiring compliance with the statewide land use planning goals noted in this memo support the conclusion that the city's obligations to comply with the requirements of Goal 15 within the boundaries of the Willamette River Greenway must take precedence over a housing developer's right to clear and objective standards within the Greenway. The criteria in Eugene Code 9.8815 are applicable to this application, end quote. So based on the city attorney's memo, the appeal statement, the hearings official erred in concluding that the Willamette River Greenway approval criteria do not apply to this application. They do. That said, in the case the Greenway approval criteria was found to apply, the applicant did provide arguments as to whether the application satisfied the criteria. As the Greenway approval criteria do apply, I'd like to turn to some of the applicant's assertions and the hearings official's erroneous conclusions concerning those criteria. Focusing on the on Eugene Code 9.8815, subsection 2, it states that to the greatest possible degree, necessary and adequate public access will be provided along the Willamette River by appropriate legal means. The applicant argues, and the hearings official agrees, that the existing bike path along the river is sufficient to satisfy the provision. However, the beginning of the section states that the Willamette Greenway approval may be granted only if the proposal meets the criteria. The fact that there is access along the river by other means other than the subject property is irrelevant. The focus is on the subject property and the proposal that relates to it. Again, the proposal must meet the criteria, not that the proposal must be situated where the criteria might be construed to satisfy the factors by existing conditions. The provision states that the proposal must provide access along the Willamette River. And this proposal, there is no access to the Willamette River or the bike path. Quite the contrary. The proposal includes a fence separating the development from the river, giving credence to the intent of the provision, developing a plot of land to the maximum density allowed by code, and then erecting a fence to preclude any access to the river is clearly against the intent of the provision. The applicant does not include access to the Willamette River as expressly required by the code provision. Therefore, the hearings official has erroneously decided that this provision has been satisfied. Next issue I'd like to address concerns the applicability of Eugene Code 9.8815 subsection 3, and thereby policy 3D5 of the Metro Plan, which provides that new development that locates along the river corridors and waterways shall be limited to uses that are compatible with the natural, scenic, and environmental qualities of those water features. The hearings official simply relies on the fact that the application satisfies the R2 zoning requirements. R2 zoning occurs all over the city. In this application, however, the development is subject to the additional requirements because it is situated in the Willamette Greenway. Neither the hearings official nor the applicant provide any evidence that the new development was in any way limited to uses that are compatible with the natural, scenic, environmental qualities of the Willamette Greenway. Instead, we have a development containing the maximum density possible in an R2 zone. More on density in a minute. And there's a contiguous fence along the entire frontage of the property, none of which indicates any consideration of limiting to uses that are compatible with the natural, scenic, and environmental qualities of the Willamette River Greenway. Again, R2 zoning occurs all over the city, but this R2 zoning is subject to the Willamette Greenway approval criteria, and there was no evidence put forth by the applicant that this provision was satisfied. For this reason, the hearings official erred in concluding that the provision was satisfied. Last issue I'd like to address concerns the application's net density calculation as it applies under Eugene Code 9.2751, subsection 1C1. And I would like to point out that this particular standard is clear and objective. Net density is the number of dwelling units per acre of land in actual residential use and reserved for the exclusive use of residents in the development. The standard is clear and objective because the operative terms, actual residential use and exclusive use of the residents in the development, are either satisfied or they are not. It is either for the exclusive or actual residential use, or it is not. The net allowable density is calculated using land and, again, an actual residential use and reserved for the exclusive use of the residents. The application only deducts the Lombard Street extension from the density calculation. However, the portion of the property on the opposite side of the fence facing the Willamette River certainly is not reserved for the exclusive use of the residents, as the residents are precluded from accessing that portion of the property by the fence. Additionally, the hearings official relies on a staff memo to include the leasing office in the calculation, stating that the office is for the use of residents who wish to reside at the development. It's not preposterous, it's not absurd. This assumes that anyone wishing to check out the viability of living in the development will necessarily go on to live there. So does this mean that the only people allowed in this building are those who sign a lease agreement that they are going to actually rent one of these apartments? The leasing obvious is obviously the interface by which the public, not confined to guaranteed future residents, can access the site. This is a commercial use, not a residential use. The provision states that only land used for actual residential use and exclusive use of the residents. This express definition also implicates the maintenance building. No resident will be living in the maintenance building, and likely no resident will have access to the maintenance building. Thus, the maintenance building should also be excluded from the calculation. As the provision expressly excludes public and private streets, I'd like to address the paved portions of the application. The application extends Lombard Street to run parallel to River Road and proposes to pave a road between River Road and Lombard. This falls under the definition of a street. The hearings official relies on the applicant's assertion that this area is a driveway, as it lies outside of the public right-of-way that abuts the access connection and allows for vehicles to move to and from a development site. But here, the area does not abut the access connection. It connects two public streets and allows vehicles access to and from one public street to another. Conversely, curiously, the hearings official also relies on the staff report, which characterizes the area instead as a parking drive. However, parking drives are not supposed to allow through motor vehicle traffic. The area between River Road and Lombard clearly allows through motor vehicle traffic. Curiously, the hearings official does not actually make a determination whether the area at issue is a parking drive or a driveway, but simply concludes that the area in question should not be included in the density calculation. This area is clearly a street. It may be a private street, but again, public and private streets are to be excluded from the acreage used in the density calculation. There are two paved portions in this application, the area between River Road and Lombard and the eastern spur, which connects to Lombard in two spots to the north. The eastern spur is not a driveway, as it has two access points as opposed to the singular access point expressed in the code's definition, and it allows through motor traffic to access a public street, not confined to only a development site. Therefore, the lack of a clear determination of whether either paved portion is a driveway or a parking drive precludes a finding that the proposed application utilized the correct land acreage in the net density calculation. For these reasons, the hearings official erred in finding that the net density calculation in the application was sufficient and thereby that Eugene Code 9.2751 was satisfied. And Mr. Reeder mentioned something about subsection 1 of 9.8815 having to do with setbacks. And as much as the 250-foot measurement sounds really nice, the setbacks aren't measured from the river, so that 250-foot measurement is quite irrelevant to the determination. Also, Mr. Reeder mentioned that there is another intervening property. However, you cannot satisfy the criteria using other properties. For these reasons and those delineated in the appeal statement, the Assistant City Attorney's memo, and even portions of the staff report, the hearings official decision should be reversed and the Lombard's Apartments application for the various permits should be denied. Thank you for your time.
Any planning commissioners have any questions?
Well, I've got one more
Okay.
for the
Oh, you do.
appellate, so
Great.
I want to go ahead and let them go through and then get their time allotted. Okay, so we have.
Thank you.
Thank you. Glenn Manzak, did I get that right?
Glenn Manzak, 119 Fur for 32 years. Apologize for running you out of the room the other night. I was just frustrated, and I had an epiphany, and I realized that what we say may not make any difference, but I just want to let you know that we treat our neighborhood kind of like classic cars. Okay, people appreciate their classic cars, they take care of them, and they want to keep them nice. My house and this house across the street are Potter houses. They were built in 29 and 31. They're the only brick two-door houses on the east side of River Road to Beltline, and I don't know of any others personally. I'm a bricklayer in my past, so I know a little bit about bricklaying. If I could, the first night I spent my house, I said, oh my God, what have I done? Because here I am on the trains. They're going back and forth all night long. I know. Okay, so the third or fourth night I'm there, I'm going, I didn't even hear them anymore. And I'm going, wow, this is pretty amazing. So over the years, I've had to build the fences higher, and I've moved them back more and given plenty of room to any kind of expansion. But if you come through there with 40-foot wide, new approved code, there's not going to be much room to my front yard or my backyard, and I have all my cars parked inside my property and not on the street. If this goes through, I would appreciate it if we have no parking signs on First Street and that they provide parking for all of their people that plan on living in their apartments. So far, that hasn't been the case at Echo, but that's neither here nor there. So I know we're all in the middle of a perfect storm, the way this code went through in 2017, and it really didn't show much empathy for the future of River Road, because 99% of River Road on the east side is no sidewalks. I've got pictures of all of them if you would like to see them. And I think the neighborhood would appreciate you members of the planning committee coming out to our neighborhood. Like Hacksaw should have come out to our neighborhood and said, well, we want to do this with that. And maybe we could have worked with them, but no. There was no planning with the people that live in the neighborhood, and we feel kind of left out. But this is nothing against any of you guys, because you're all part of the perfect storm. And we're all people, and the epiphany told me that I will not sleep if I put too much time into this. Guys, have a good evening.
Thank you. Thank you.
So, sorry, I jumped the gun last time. Is that it for the appellants? Okay. Are there any questions?
I do have a question. It's just a clarifying question for Ms. Sesteda, is that who you say? So I just wanted to clarify. So your opposition, what I have in my notes is that you don't oppose housing on this site. that your opposition is specific to the type of housing being market rate housing versus subsidized or affordable housing, such as something that a HACSA or Homes for Good would build, which would also be subject to the same requirements for their application if this were a development that was being done for affordable subsidized housing. So just trying to clarify what your specific objective or objection is.
I support low-income housing.
Okay.
Because there's such a need for it. And looking at the history of low-income housing in Eugene, it would never be 94 units. It would be a reasonable amount, maybe 50, which River Road would gladly open our hearts.
Okay, thank you.
Perfect.
All right. Got a pile here of folks that want to speak against or in opposition, and I'm going to go ahead and start with Janine McIntyre.
Good evening. My name is Janine McIntyre, and I live at 370 Lombard. I would like to echo some of the things that my neighbors have said, and I don't want to repeat that, as that is already things that you are going to be taken into consideration. One thing that I would like to add with regards to the density and talking about what is best for the community, adding 94 units almost quadruples the number of residents in our 3 streets that would be primarily impacted. And quadrupling the number of residents is going to dramatically impact the community at large. So I just would like to state that. I would also like to echo that these are going to be at market apartments. And while in the statute, it says that needed housing is at market and also includes Section 8 housing, I would also like to echo that we do have many vacant at market rate value apartments in the city. However, if we're looking at what's best for our community at large, I would like to ask the company that is going to be proposing this and our city as to how do these 94 apartments positively impact our families that are living here when we have more than 8% of our students in school-age students that are homeless. If this was really going to be a positive impact for our neighborhood and our community at large, we would be providing spaces so that we don't have the highest homelessness rate in the state of Oregon. So that is my comment, and thank you very much for your time, and have a great evening.
Thank you. Are there any questions?
Okay, next we have Steve Goldman.
Okay, good evening, Ms. Taylor and members of the Planning Commission. My name is Steve Goldman. I live at 1495 West Hilliard Lane. I speak to you as a land use planner with 33 years of public service experience. Rodney, can you put up the development plan up on them? This project presents an opportunity to take a stand for the values embodied in Envision Eugene and the 7 pillars of Envision Eugene, the Metro Plan and the River Road Community Plan, and the state of Oregon's Willamette Greenway Law. It's extremely sad for me to see this proposal on this beautiful piece of land next to the river that I ride every single day on my bicycle. I grew up in Los Angeles in the 1950s and 60s. I saw Los Angeles transformed from what was actually an attractive place that had open space, it had orange groves and lemon groves, and now wall-to-wall housing, apartments, and parking. I moved to Eugene because it's a beautiful place. It's still a beautiful place, but it's becoming not a beautiful place if you accept something like this, which is clearly unimaginative and not in alignment with your own values. The developer argues that the Greenway Law doesn't even apply to this project because it's not clear and objective, but your city attorney finds differently that it does apply. When you look at that plan, you can see that the only thing that maximizes for is apartment units and parking spaces. In other words, profit. The design maximizes for profit and nothing else. It's extremely sad to see this city staff go along with this. Not a single one of the 28 trees on this site, which I looked at, and there are many beautiful trees, not a single one was proposed to be saved. 60% of the site is proposed to be covered with impervious covers, which is extremely harmful. I did water quality planning for 33 years. 60% coverage is horrendous for water quality, and only 15% for open space. How is that anywhere near maximizing open space? I mean, any reasonable person would say, I mean, maximizing to me is over 50%. This isn't even close. One of the Eugene pillars says to provide,
30
you know,
seconds.
all types of housing, affordable housing. I met with Mr. Fox, the director of Homes for Good. The reasons for selling this property that were given are bogus. It was an economic decision. This would be a great place for some affordable housing on the River Road side, and I would support that. You have a chance to make a courageous decision that stands up for the values of this community and not out of fear that you'll be sued. I hope you'll make a courageous decision to stand up for what this values the city has adopted.
Thank you.
Thank you.
Are there any questions?
Okay, sorry. Next, we have Brad Foster.
Hi, I'm Brad Foster. I live on 1315 Bailey Avenue. That's off North Polk. I submitted a letter from the Whitaker Community Council. Those backyards that are just on the south side of this, those are all Whitaker backyards. We weren't notified of any of this till just recently. We're kept out of the loop completely because it's right on our edge, though. But that's not really what I'm here. I'm trusting you can read the letter. It's different. I'm here because you said at the beginning that your job is to make sure that city policy is implemented. And our city has some inspiring policies. I'm in awe at what our city council has passed. Our climate change recovery ordinance, which then begat our placing active transportation above motorized transportation as a policy, which begat Vision Zero and also a goal of getting 30% bike modal share by 2035. These sorts of proposals where you're going to take a very quiet entrance from the hellacious River Road for people engaging in active transportation. They come off River Road onto Fur Lane to access those bike paths. You add several hundred cars a year to that, a day to that, that's gone. You're taking away our ability to get people to move by bike and to get people to walk. You widen those roads for those cars, it's even worse. Who do you see walking and riding on River Road? Not much. I had some neighbors, they tried riding on River Road. 2 kids are gone, just gone. Okay, we need to have you implement city council policy. Staff is not implementing policy. Public Works has yet to implement the climate change recovery ordinance. They continue to facilitate cars over bikes and walkers. Planning, same problem. They're following policies that are decades old. Our policies have moved on. They're following guidelines that are decades old. Our policies have moved on from the city council. You are the people who need to make sure that happens. No more business as usual. Council says we need to go someplace we haven't been. You need to take us there. Thanks.
Thank you.
Questions?
Next, I have Dennis Sondow. Apologize, I can't quite read that. Sandow.
Thank you. Dennis Sando, 123 Fur Lane. Before we start the clock, Chair Taylor, my experience as a planning commissioner for the county in Lane County and Deschutes County. In your introduction, I didn't hear you describe the Eugene Planning Commission's role as a CCI, that is Citizen Involvement Committee. Could you clarify, is this the case? Does Eugene Code have you duly appointed to both a planning commission and a citizen involvement committee?
In terms, I'm going to have staff talk about that. Formally, I mean, we have a part of our bylaws, our charter, that addresses public participation. But in terms of a citizen involvement committee, I'm not quite sure. We don't.
Commissioner Taylor, if I may.
Yeah, please.
In Eugene, the Planning Commission does function as the Citizen Involvement Committee for
So we're
goal line
directly,
purposes,
yeah, thank you.
This is fascinating, and I'll get to the reason why, but some more, just for accuracy purposes. What got us here is the applicant did withdraw their application, but it was after citizens pointed out that they had the wrong address on the application. This whole application's been fraught with sloppy work. Even in the applicant's packet that you'll find, if you look at one of their site maps, you'll see that it's labeled Shevlin Multi-Family Apartment Complex, Bend, Oregon. The other error made by the applicant's attorney is that the property is not owned by the developer. The property is owned by Homes for Good. Again, that's on the application. Excuse me. Like you, when I joined the Lane County Planning Commission, I didn't know either that I served a dual appointment. I was a member of the Citizens Committee for Involvement. I brought this forward to my fellow planning commissioners in 2011. They were also not notified nor aware that they had a dual function to serve as the Citizens Committee for Involvement. I'm glad one of the applicant's attorneys brought up LUBA, because I'm afraid this is where this is going to go. This is the single most denial of Goal 1 policy that I've ever seen. This property was designated, Mr. Bonner, could you put up the vicinity map again? Thank you. Again, you'll see East Briarcliff, Lombard, and Fur Lane. All those properties adjacent to the application are in Whitaker Community Council. Homes for Good, the owner, has gone to the River Road Community Organization, not to us. Homes for Good sold this property as we supported their development in affordable housing without our notification. We had no idea that this was going to happen. I'm showing you a couple of pictures on the right-hand side of the picture, of the photograph. Oh, I'm sorry you didn't get a chance to see that, but you'll...
Dennis, you have about 15 seconds.
About 15 seconds. Okay, well, I'll tell you this. In our neighborhood on Briarcliff, there are many people with physical disabilities, seniors and senior care homes that use Briarcliff, Lombard, and Fur for access due to ambulatory needs. This is going to be brought up in an American with Disabilities Act suit because this project denies access to traffic-calmed arterials by people who are presently living in the neighborhood who require ambulation. This is not about providing homes for people that need it. The homes that need it most, the people that need it most are people with disabilities with ambulatory needs. About 46% of the people with disabilities in Springfield and Eugene. Thank you.
Thank you. Any questions?
I do have a question. Could maybe staff clarify the boundary, the neighborhood boundary? I'm just curious. I didn't realize that Whitaker. Does anybody know?
I'm not familiar with exactly where the boundary is in relation to the subject
Okay.
property without looking at the city's website and the current maps.
Let's hold questions for staff till the end. Okay, great, thank you.
No problem. Okay. Next, we have Jolene Seisman. Oh, Seamson?
Hello, good evening. Thank you, commissioners, for hearing our comments. I'm speaking in opposition to the proposal that's been made for the Lombard development. My name is Jolene Simpson. I live at 190 Hawthorne Avenue in the River Road neighborhood. I am a River Road Community Organization member. I've lived in the neighborhood for over 30 years. I have biked the river path to and from work for 25 years. I feel I'm intimately acquainted with this particular part of the world because I've seen it through all seasons and all weather. I also am a former River Road Community Organization board member, and I participated in other community involvement related to planning and development of River Road. I just want to read my statement. I urge you to reverse the hearings official's decision on the proposed Lombard Apartments based on Eugene Planning Staff report issued on August 30th, 2018, regarding appeal issue number 1. The hearings official erred in finding that the Willamette River Greenway approval criteria do not apply to the subject application. Therefore, the application should be denied. And I do want to make a few comments based on other things that have been said. I want to make it clear that the neighborhood and our community is not opposed to development of housing in this area. We realize times are changing and this is part of our future. I think we fully support affordable housing development in our neighborhood. And as a case in point, we're working quite closely at this point with St. Vincent de Paul in developing another piece of property further north, which is also adjacent to the river path. And St. Vincent de Paul has done a wonderful job of meeting with the neighbors many, many times to work out the plan and make sure that it fits with our community vision. I would take issue, number 2, with the statement that there is an additional 150 feet of setback. I think this is a disingenuous statement. And in fact, I think you could look at what the definition of the greenway is and what that encompasses in terms of the life of the river if you want to get into the deep ecology of the river. I can tell you that that additional 150 feet is part of the floodplain. There are many times riding through where I see water standing, I see ducks swimming, and there are also native trees and other native vegetation growing in that area, which represents the ecosystem of the river.
30 seconds.
Thank you. I would say that this proposal affects more than the neighbors, which I feel is used in a somewhat pejorative way and diminishes our interests here. I think that what's happening here represents a broad area of public concern. This land deserves application of the greenway protection provided by Goal 15. The legacy of greenway protection will stand long after this decision is made. Thank you.
Thank you.
Okay, next we have Kelsey Hannanen.
Hello, my name is Kelsey Hanonen, and I live at 1455 East Briarcliff Lane. I want to say thank you for your time, and this is the first time I've seen more ladies up at the booth than guys, so woo! That being said, I do want to, pick on you for a sec, Miss Taylor. We are also human, and what I see here is a lot of humans, neighbors, coming with real concerns. And what I hear over here is an entity saying what they're entitled to. These are people that are concerned about the traffic, they're concerned about the parking, they're concerned about the general aesthetic of their neighborhood, and they're also concerned about a better option to make Eugene, Eugene, and to maintain it as the place that we know and love. I'm asking you guys to specifically appeal to this. I think we can do better. The neighbors have put forward a couple of different options that they'd be stoked about. Tiny houses, low income. At least we couldn't morally argue against that. This, I could get a market rate apartment tomorrow if I wanted to. I feel like we could do better here. I feel like there's better options, and I feel like we could have something that is truly great and outstanding in that space because that's what it deserves. That's all I have to say. Thank you so much.
Okay, next, Anastasia Sadao? I apologize. Sando.
Greetings, commissioners, staff, and fellow neighbors. A lot, I guess what I was going to say has already been talked about, but I'm going to just focus on traffic. My husband and I, Dennis, live at 123 Fur Lane. We've been there for 30 years. We raised our kids there. They rode bikes on the nice 3 dead-end streets there. They also graduated high school in that house. We are still there, and we've passed the word to family that just, buries in the backyard. I am concerned about the traffic. We were told by city staff at the beginning of this process that it could be up to 600 cars a day coming down Fur, Lombard, and of course, affecting Briar Cliff a little bit more indirectly, but still affecting all of us as we get to our homes. I don't believe that this is a compatible project for that land. I am not against, I support infill versus urban sprawl, but I don't think that it's fitting to be doing this on Class 1 soil. Let's see. The other thing I want to say is that we are very neighborhood oriented. Everybody knows everybody pretty much. You know who comes and who goes. And just to give you one small example, our neighbor, Emery Blackwell, if he is not out on his wheelchair and his dogs aren't barking up and down the street that day, somebody's going to knock on the door. Thank you for hearing.
And next we have, I believe it's Renee Brighton.
I am so sorry. I am not actually speaking directly on this issue, but I do have some questions after attending today. I guess one was namely, it sounded like somewhere in the testimony, it was said that there wouldn't be provision made for public access to the river based on the purchase of the space, if it were purchased. And I don't know. So I did have a concern about lack of public access to the river. But mainly, since I'm not totally in the jive of this particular project, I'm not even sure if it's the same project I read about, the River Development Project, listed online for 20 something. And just for that, I had read that there was some concern what was going to be laid out. Well, it was going to be a nice space aesthetically and in terms of young families or whatever, but that there would be provisions for, monitoring of unsafe or inappropriate behavior. And it's just been brought to my attention that, downtown is really right now bereft of youth services, as far as I can tell. The first 3 things that come up if you do an internet search for Eugene downtown youth services are homelessness, hunger, and crime. So I honestly think that just as Eugene, we could be doing a lot better, as some of the neighbors had mentioned about, green space. But also just in terms of the youth, where the initiatives are for sort of activity centers. We have the library, but now homeless youth who might ride LTD or who might come downtown to look for the arts or to enjoy the, sorry, I don't know how much time I have, or to sit in Kesey Plaza. They can't smoke cigarettes. They can't buy cigarettes if they're under 21. And I don't see a lot of just like a more supportive atmosphere for that.
30 seconds.
Okay. And so I would love to see an initiative for a youth center downtown rather than initiatives that sort of.
Renee, I just want to clarify, we're specifically here for a hearing on this particular project, so.
I'm so sorry.
Yep, that's all right.
And I'll just finish by saying I also think that Eugene would be more welcoming to artists downtown without passing measures that preclude different people and move them along. So that's all I have to say. Thank you so much for your time. And I'm sorry, my name is Renee, and I live at 55 West 22nd Avenue.
Perfect.
Thank you.
Thank you.
All right, we've got two more. So Penelope Tyrell.
Hello, my name is Penelope Tyrell, and I live at 93 North Polk Street. I also own the corner market right on River Road near where the proposed site is. And I guess as a business owner, this might be good for me, but as a denizen of this place, it's not good for me to have that many people all crammed into this one little spot next to the river. And I didn't really read the whole hearings official thing as far as what he chose to do. I hear a lot of people saying that he was mistaken. I have had 2 hearings with this same man in the past month, 2 months. And I know that in my hearing, he did not really do due diligence. One of them was a tree removal hearing where they needed to mitigate the loss of habitat. There was 30 trees in the property. Now there's 20 market rate condos going in 2.5 blocks from this site. So that's already 20 expensive homes in a neighborhood that can't really afford that kind of rent anyway, crammed in between some low-income housing and the teen housing that Nedco put in. I don't know who's going to spend that much money to live in those condos, but they're being built. This morning, they took out a 100-foot tall tree. I'm trying to think of what kind. A Lebanon cedar. It was a beautiful tree. You could see it all over the neighborhood. I woke up to this morning to that tree on the ground. But that being said, this man, I believe his name is Mr. Wilson, in his appeal thing, said that I didn't understand what mitigate meant. I understand what mitigate meant. I don't think he really took the due diligence to really understand what loss of habitat is. As you can see, I have one picture of before and after, and I also have one here. This is before, that is after. Taking out 30 trees does not mitigate. There's no putting in 3 saplings to do that. It's no mitigation. You take 30 big full-size trees and everybody that lives in them, put them on 3 little saplings in a hedgerow. Okay. Anyway, I definitely challenge that man really has the best interest of anything except for just saying yes. Okay. Anyway, that's my experience. And I think our neighbor can do a lot better. And we really do need to have housing for people that elderly and need to have more ambulatory things. And I used to live on Fur Lane, and I know all those people that live there, and I know I lived on Briarcliff. Anyway, that's my neighborhood, and I think you should really think about what's going on here because I think it's the wrong choice for us. Thank you.
Okay, we've got one more speaking in opposition, and that would be Cindy McLaren.
I guess I'd like to state I'm a little bit neutral, but somewhat opposed to the plans that have been made for this development. I lived on Lombard Lane from 1983 to 1999. After Lombard Lane used to have a metal bar at the end of it, so nobody could drive into that field that they're planning on making this development. And somewhere during that time period, somebody was proposing to buy that property, and they said they wanted to make that a through lane. And we said, no, we don't want that. And they said, okay, we'll take out the stoplight that you have at the end of Fur Lane, which they did. So we no longer have a stoplight to ease in and out of traffic. And apparently they're breaking the thought process that they weren't going to make this Lombard Lane through. During the time I lived there, they expanded the park and put in a large parking area. And I cannot tell you how many close misses I have had on being hit by somebody coming out of that park or making that turn around Fur and Lombard. That's a very dangerous intersection. If the developer wants to bring in all these property and bring in 98 units, they need to provide the access out to River Road. They don't need to be coming through a lane that is a very dangerous one, as is with the low amount of traffic we have. I currently live at 1359 Parnell Drive near the Echo development. And again, I don't particularly care for the development, but they didn't provide enough parking for the members that live there. I think this one has 1 car per house. I don't remember. Well, that's unrealistic for the neighborhood. All the properties around Echo development now have cars parked in front of their houses from that development. And people are putting their garbage cans in front of their houses so people won't park in front of their house. And that just ruins the whole look and appearance of the neighborhood. So if the developer wants to have this property, they should provide adequate access in and out of it without destroying the local neighborhoods, and they must provide adequate parking, because estimating 1 car per house is just unrealistic. It's nice to be able to ride your bikes to work. It's nice to be able to ride to and from grocery shop, but a majority of people cannot do that. Thank you.
Thank you. Any questions? Okay, that concludes the public testimony at this point. And now, does staff have any comments?
No significant comments right now. We appreciate everyone's time tonight. There's a couple points that we'll follow up on to provide some clarification, including potentially new arguments, just to ensure those and to clear up where our road name data came from, in case you're curious.
Perfect.
Thanks again.
Thank you. And are there any questions for staff that is particular to the testimony?
So I heard several complaints about public notice and that the Whitaker area was not communicated with. Could staff please describe what type of public notice or community involvement happened around this project?
Well, my understanding is that with the Type 3 application process, what is required by code is that the neighborhood association within which the project is located must receive the notice. I can't speak to any other outreach that the applicant may have done to Whitaker Community Council, but I know it's not required by code in this case.
I'm sorry. Yeah, let's.
The map of the Whitaker neighborhood is both sides of Briar Cliff. So you're incorrect in saying that Whitaker is not connected to this project, because they are. And I went to one of the neighborhood meetings at the beginning of this process.
Ma'am.
I had no idea this was going on, but they do now.
Perfect. We'll let staff clarify that. Yeah. Thank you.
Yeah, we'll follow up.
Okay, thank you.
Happy to.
Commissioner Baker.
Well, follow-up question to that, and then I have another question too. Aren't you required to notify areas within 300 feet, which would include any neighborhood groups that would be within that?
Includes owners and occupants within, I believe, 500 feet.
Okay, and not neighborhood groups within that same?
No, sir.
Okay. My other sort of more substantive question is a question regarding some language. Language in the Greenway, the resolution adopted in 1976 has the wording, provides that, quote, private development within the Willamette Greenway will be viewed to ensure that adequate provision has been made for public access to and along the river. And then it has comma consistency with local plans. Yet in our own metro plan, we seem to have dropped out to and along, and I'm just curious if that was intentional or it was just a shortening of the language in here to something that was put in our.
Unfortunately, I can't speak to the intent of the legislators or the council at the time that may have adopted our specific regulations in the mid-'70s, but I don't know if city attorney has anything to add on that. I know it's not in the record.
Thank you. Does that conclude the questions? Okay, so next we'll move to the appellant's final rebuttal. Oh, sorry, applicant's final rebuttal. It's getting past my bedtime, actually.
Again, for the record, Mike Reeder, attorney for the applicant. And with me is Andrew Brand, representative of the applicant. We're going to take a little bit of time tonight for rebuttal since you have a very short window in which you have to make your decision. And my understanding is correct that you're deliberating tomorrow. And so we're going to go through this a little more methodically than we normally would because there is no open record period. So bear with us as we go through this. There's nothing more frustrating than sitting through deliberation of a deliberative body when the record is closed, when the deliberative body still has questions that they could have asked the applicants or the appellants. So now is your time to ask any clarifying questions. We're happy to answer those for you. So feel free to jump in as we go through this presentation for our rebuttal, please. Okay, so generally speaking, we've heard quite a bit of testimony about matters that are not within the confines of the application and specifically the appeal issues. And that's understandable. This is a public hearing, you're volunteers, and so it's an emotional issue for people. But what I'd like to do is focus us back on the criteria that is in front of you. So to that end, I will talk about some things that relate to the criteria and respond and rebut some of the testimony that was provided. The first one that I think is critical is the issue regarding the Willamette Greenway Criterion 2. And so let me direct your attention to that. That is, and we addressed that in the written comments on page 3. I'm sorry, page 4. It's appeal issue number 3, but it's the Willamette Greenway Criterion sub 2. To the greatest possible degree necessary and adequate public access will be provided along the Willamette River by appropriate legal means. So you've heard testimony that attempted to respond to our testimony that says that this criterion requires, if it is applicable, requires access along the river. The hearings official and staff both correctly identified the fact that this property is not adjacent to the river. It cannot provide access along the river. That access is provided by the ownership of the intervening property by the city. And there's plenty of access there. Okay, we've got a bike path that's there along close to the top of Bank. We've got parkland. So that Willamette Greenway policy that was established when Goal 15 was adopted is met because of public ownership. So here we have privately owned property owned by Homes for Good, proposed to be developed by my client, that is adjacent to property that meets this criterion for approval. Now, Mr. Woodward focused on the language that says that it has to do with the proposal, and that's correct. To that end, you are looking at the proposal, but you only look at the criteria, the standard, when it applies. And here, by its terms, this provision does not apply. Now, there's kind of some superfluous language in the hearing's official decision, probably in our application material, that talks about that, oh, by the way, there is a provision for access along the river, but don't miss the fact that this provision is not applicable. There was some testimony regarding traffic. Now, if we didn't have traffic issues in land use hearings, we'd almost never be arguing about anything. Traffic always comes up. And it is always the case, you have a competent traffic engineer, third party, hired by the city, who analyzes the standards that have to do with traffic. And that engineer hired by the city has agreed with the applicant's traffic engineer, Ms. Sandow, that the application meets the requirements for traffic. Sure, we'd all like less traffic. But the fact of the matter is that the record is, in the record, we know that Coburg Road has substantially more traffic than River Road. Does that mean that River Road is perfect? Absolutely not. The fact of the matter, there's been a lot of talk about the 7 pillars of Eugene. Well, the 7 pillars of Eugene have, as is customary with land use planning goals, they can sometimes conflict with each other. But the idea is that we as a community have decided to infill along key transit corridors, River Road being one of those key transit corridors. So on the one hand, you have a key transit corridor that probably will receive the MX bus line, but in any case has LTD bus service. And on the east side, you have a bike path. That was one of the motivating factors for entering into contract with the owner of the property, was because there are alternative methods of transportation. It gets me to my next point regarding parking. Again, traffic is always number one, parking is always number two on these land use issues. On the one hand, you have people who are concerned about too much parking, too much impervious surface, too much dependency on automobiles. And on the other hand, you have concerns, legitimate concerns, about the adequacy of the on-site parking. In this particular case, there are 94 proposed units. The code requires 94 on-site parking spaces. The applicant has provided, I believe it's 120 some odd parking spaces. 127, which gives us 1.35 or so parking spaces per unit. So we believe that this is a reasonable amount of parking given the proposed development, given the size and the location of the subject property. There was some discussion about the name of Lombard Street. I don't want to get into the semantics, but only to make sure that you understand that the name of the street has nothing to do with the classification of the street. I trust that you understand that, but I just want to make that clear. And it's not the applicant who is calling it one thing, it's the maps that are produced by the city. So whether it's Lombard Lane, Lombard Street, the applicant doesn't care. It's not a relevant consideration. Getting to Mr. Woodward's, the bulk of his testimony, he testified regarding access along the river, and again, subsection 2 of the Willamette Greenway permit issues. What he didn't do is he didn't address our main argument that I just identified for you earlier in our rebuttal testimony, which is that the text of the text of the Willamette Greenway provision requires that the property be, or that the proposal provide access along the river, nor did he address the argument that we made that is in regards to subsection 3 of the Greenway permit, which requires that The intensification, change of use, or development will conform with applicable Willamette Greenway policies. And that policy that I talked about, D5, says new development that locates along the river corridors and waterways shall be limited to uses that are compatible with the natural, scenic, and environmental qualities of those water features. What Mr. Woodward did not address was the fact that we are talking about a type of use, not the features of that use, including the height restrictions of the R2 zone. And that's an important point. As we provided for you on page 6 of our written statement, kind of a regurgitation of what the hearings official found in regards to the net density calculations. And I, you know, with all due respect, it's difficult for me to argue with vigor a preposterous position. And that preposterous position is that the accessory residential uses of this project, including the maintenance building, including the leasing office, including the open space, is somehow a commercial and or public use that should be debited out of the net density calculation. That is simply a non-starter. The accessory, the fact of the matter is that the exclusivity portion of the code has to do with the fact that it is exclusively residential. Not that no one who is not a resident won't be on the property, and that's really what they're arguing. There's no other way to look at it. So of course the leasing office is not commercial in nature. The whole point is for the leasing office to bring folks into and become residents of the property. It is an accessory use to a multifamily development. And the fact of the matter is that the appellants don't provide any examples of where this has ever been implemented, that their theory would be implemented, and it's because it's absurd. There was some testimony regarding the fact that this 94 apartment unit would quadruple the number of residents in the area. I'm not sure that that material is in the record, so I don't have the ability to rebut that in its specificity. But to the extent that it may be in the record, it's irrelevant. The fact of the matter is that the Metro Plan designates this property as medium density residential. It has a nodal development overlay, which encourages increased density. The applicant is meeting the goals and the policies of the city council, which is to encourage infill and redevelopment. And this is a great location for that infill and redevelopment. One of the opponents talked about the maximization of open space and vegetation, and really, you know, I think the calculation was that there was 60% of the site that had impervious surface, and that's not maximizing. Maximizing would be 50%, et cetera. The problem with that is that the issue that I have with that is that that's not the standard. Maximization is a subjective or a fuzzy or a discretionary term of art, which illustrates why Senate Bill 1051 is so important in the needed housing statute, because these types of housing developments get stalled by arguing about things that are undefined. And you could have 10 land use planners line them up and ask them this question, and they could give you 10 different answers about what it means to maximize. One of the issues that was raised was the fact that this property is entirely within the Willamette Greenway, and there was a lot of discussion about that. The fact of the matter is the property to the south that's developed with single-family homes also is in the Willamette Greenway. So we know that residential development is not per se incompatible with the Willamette Greenway. I would be interested in knowing specifically about the Greenway resolution from 1976 that was referenced by Commissioner Baker. Is that in the record? I'm not sure what Mr. Baker was referring to, so I can't respond to it.
The attorney's testimony that was submitted in the record.
Is the actual resolution provided?
Well, the wording is actually typed in her resolution.
Oh, in the memo, not the okay, in the memo, the city attorney's memo.
Yeah.
Great,
The memo
okay.
quoted some provisions of Goal 15, which I think is what we're talking.
Okay, I just wanted to make sure there wasn't some type of local legislative history that was outside of the record that we weren't privy to.
Not that, Commissioner Baker, you were reading from the city's
Okay,
memo.
great.
Just reading from her testimony.
Thank you for that clarification.
I just wanted to make a few other comments that hopefully are pertinent. One of the things that the representative from the Neighborhood Association brought up was that they were neutral, but what they would like to see, I believe it was L3 screening and landscaping within the 100-foot setback. I just wanted to respond to that specifically, and without being with the full code and full record of notes, there was actually a lot of discussion with city staff about what could be done within that 100-foot setback, the area basically between our building 1 and the edge of our property. And if I recall correctly, there were very specific provisions about the type of landscaping that could go in there, which, and again, I'm just saying if I remember correctly, I could be wrong, but just for discussion later on is that L3 landscaping may actually not be allowed in that 100-foot setback. I remember there being very specific discussions with staff about the types of grasses that would be planted and sort of still actually keeping it as an open environment instead of walling it off with landscaping. If I'm wrong, I'm wrong. I just wanted to bring that up just to make sure that it was something that if it became a point of discussion, that was looked at in the context of the code. I do know that we meet the code requirements because of the discussions that we had. So anyway, just a point there. Another thing I wanted to address was one of the comments, and I don't remember the provision of code that it was referencing, but there was a comment to the effect that that under multifamily housing, there are criteria to basically provide a benefit to the community and that our project provides no benefit. I wanted to take exception to that, especially in light of an article that I think was just published either today or very recently in the Register-Guard talking about the housing crisis in Eugene, rental housing rates going up. And I think this is a element that people can agree to disagree on, but I personally, and I think a lot of economists, fall on the side of supply is good for housing affordability. Does market rate housing provide under market rents? No, it typically does not. Rent restricted, income restricted housing is extremely expensive to build. If there was more money to build it, I suspect HACSA would be building more than the 300 units that somebody said that they would be building in the future. But, to say that producing more housing is not providing a net benefit is, I think, just a statement that I would take great exception to. And I do think that providing more supply and allowing more supply of housing, especially dense housing, we're creating more opportunities for people to find more places to live, taking rent pressure off of the sort of, call it, naturally existing affordable housing, which is usually an older housing stock, and also actually benefiting the climate and ecological goals of growth management and growth planning in general. A couple other things here. Talk about that. Apologies.
Yeah, while you're looking, I would, apologies. I would agree with that. And again, I'm not sure if those numbers about 8% vacancy in market rate apartments is in the record. I sincerely doubt that. And I would agree with Andrew, Mr. Brand, that any front door is a good thing in Eugene when we have a housing crisis. Housing markets do not defy the laws of supply and demand. And we know even from planning consultants throughout the nation that the problem is supply. And we have a very limited supply here in Eugene. And yes, there are neighbors who showed up to testify in opposition to this. What you don't see and what is invisible are the 94 families that would benefit directly from this. You don't see them. They're not here in this audience because right now they don't have that opportunity to live there. It's vacant. It's been vacant for a long time. As I said before, this is a great location for infill. And I would like to respond to the comments that were made specifically about that speculate as to what Hacksaw might do if they developed this property, okay? There was discussion, or there was an assertion made that somehow there would be fewer than 94 units that would be provided on this property. And I would just encourage you to look back to the recent subsidized housing in the Bascom Village area, where that property was basically maximized with 2- and 3-story apartments in that neighborhood, and it was very dense development. So to assume that Hacksaw, if it had the chance to develop this property, would develop it with fewer than 94 units, I think it's pure speculation and probably not a real speculation.
Mike, if we stay consistent with the 30 minutes, you've got 3 minutes.
Yeah, no, that's a good point. I think you make that point.
Okay, so one last point here, and it relates to what we are agreeing with the hearing official regarding the Willamette Greenway and saying that they're not clear and objective and therefore they shouldn't exist. I just want to make clear that we are not trying to rail against a Willamette River Greenway standard. We're just saying that they need to be clear and objective standards. And our hope is that, council and working with city staff and with neighborhoods would in the future come up with clear and objective standards. But currently, the standards are not clear and objective.
Right. And just wrapping up to that end on the legal side of that, responding to the Assistant City Attorney's memo, there's really actually 2 statutes that are in play here. And I provide those statutes for you. That one is the needed housing statute that we hear about all the time, ORS 197-307 sub 4. The other is the corollary, but yet a distinct different statute. And that is, I will find it for you. It is ORS 227. .175, I believe. And what this says is that a city may not deny an application for a housing development located within the urban growth boundary if the development complies with clear and objective standards, including but not limited to clear and objective design standards contained in the city's comprehensive plan or land use regulations. So when you read those 2 statutes together, it's clear to us that the Willamette Greenway subjective, fuzzy, for lack of a better word, fuzzy criteria cannot be applied to this particular application. And with that, I think that's all we have, unless you have any questions. And again, we thank you for your service.
Commissioner Baker.
Yeah, I have one question, and it's related to the site plan. It's called Attachment A in our packet. Attachment B. I noticed that there are 2 buildings that are 2 stories with 8 units each over here. And the rest of the development is primarily 3 stories. And I'm wondering why those 2 units weren't made to be 3 stories, and those 8 units that would have been placed there could have been sort of lopped off the, I think you called it Building 1, and so there would have been fewer units there, and that might have allowed more open space between the activity and the river.
So I guess I'm trying to, apologies for asking. So you're asking why we maybe didn't take the 8 units in a Building 4 or Building 3 and transfer them to Building 1, creating a single mass within Building 1 that would be all 3 stories?
No.
Oh, okay. The other way.
The other way around.
Oh, well, we actually, I mean, part of the reasoning for doing 2 stories instead of 3 stories on Building 3 and Building 4 was specifically because those buildings are very close to a house directly to the south. So we were trying to keep in scale with it. It's the same reason that we stepped Building 1 on the edges and made it 2 stories up against the edge of the property line.
Thank you. Any other questions? Okay, so I'm now going to close the public hearing and the record. And as you all heard, thank you once again for coming. And as you heard, the deliberation meeting is scheduled for tomorrow, September 6th at 6 p.m. in the Sloat Room, and that's in the City of Eugene offices. And a second meeting, if needed, once again, it will be scheduled, or is scheduled if needed, for September 11th at 6 p.m., also in the Sloat Room. So before we depart, are there any particular questions that you have for staff in preparation for tomorrow that you can give them a heads up? They don't have very much time to pull together specific information if you need something for the record. Okay. Well, looks like there aren't any questions. Staff, do you have any final comments? No. Okay. Well, have a wonderful evening. You know, if you have questions, you can ask staff afterwards. I think that's what I'd recommend. No, the record was closed. The public hearing and record are closed.